On the subject of witnesses, usually complainants, changing their story, there's two main types of divergent stories. The first is recantation. The person recants. The person basically says, it never happened. I know I said it initially that an assault had taken place, but I'm now saying I made it up. I wanted to punish that person. I was drunk. It never happened. That type of complete 180 on their evidence is not that common. It does happen sometimes, but you have to be prepared for it. The next area, the other main divergent area, is minimization. So they don't go all the way and say that it never happened, but they say they were struck fewer times. They minimize the impact or the discomfort. They in some way try to lessen, without saying it didn't happen, they try and lessen the impact on the accused. A full recantation will likely result in the Crown attorney at trial bringing an application before the judge to be able to cross-examine their own witness, i.e. the complainant, and putting their original statement to them and getting them to adopt the contents and basically say, I know you're saying it never happened, but you told us way back when that it did happen, and I suggest to you that you were telling the truth at that time. And if the complainant adopts the previous statement, then it's essentially as if the recantation has disappeared. They've adopted the original statement. In the case of a minimization, sometimes the Crown will not seek to cross-examine because it's not enough for the judge to allow the Crown to cross-examine. And it's not inconsistent per se, it's just minimizing the extent of the injury or the extent of the contact. So this video is as much for complainants as it is for people who are accused of domestic offenses. As you can tell, it's a very complex area and there's a lot of moving parts. So I encourage you to get specific legal advice from myself or one of the other great lawyers that we have in this town to educate you and to represent you during your time of crisis.